What is a deposition? News coverage of high-profile cases often brings into the spotlight the use of depositions and deposition testimony of witnesses, which is different from testimony given in court. But what is a deposition and how do they work? Read on to learn about the discovery process, some basic information about depositions, and how depositions work. Overview of the discovery process. In a lawsuit, all named parties have the right to conduct discovery, a formal investigation, to find out more about the case. Pre-trial access to this information allows the parties to use facts and potential evidence to better define their strategies and avoid delays once the trial begins. In some cases, what's learned during discovery might even help the opposing sides come to a settlement without having to go to trial at all. Discovery can come in a number of different forms, with the most common being subpoenas for relevant documents, interrogatories, written questions, and depositions, the taking of an oral statement of a witness before trial, under oath. Whether a deposition is needed depends on the unique facts and circumstances of each case. Cases that involve only legal, not factual, issues usually don't require them, since witness testimony and other evidence isn't relevant to these decisions. In many lawsuits, however, depositions play an important role in painting a more complete picture of the events in question. Deposition basics. Unlike the information recorded in documents or the attorney's answers to interrogatories, a deposition involves a living, breathing witness being asked questions about the case. The deposition has two purposes: to find out what the witness knows and to preserve that witness testimony. The intent is to allow the parties to learn all of the facts before the trial, so that no one is surprised once that witness is on the stand. Contrary to what countless movies and TV shows would have you believe, springing a surprise witness at the 11th hour of a trial is regarded as unfair. By the time a trial begins, the parties should know who all of the witnesses will be and what they'll say during testimony. A deposition is an opportunity for understanding the case better and not solely about getting favorable testimony. If, for example, a witness version of events would undermine your case, that's something you'd need to know about long before trial, since last thing you'd want is to be caught off guard by hearing damaging testimony for the first time when that witness takes the stand. Basically, a deposition is an opportunity for all sides to learn where the weak spots are in their respective cases, then prepare for ways to avoid or rebut them at trial. Prepare